Guys, hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Justice Lagoa is unable to be here today, but she will nonetheless be participating in the decision of today's cases. We go to the first case on the docket, the Florida Highway Patrol versus Jackson. Counsel?
Thank you, Mr. Chief Justice, and may it please the Court. Christopher Baum for Petitioner. Rule 9.130A3C11's text, this Court's authoritative interpretation of it in Beach Community Bank, and sound policy considerations all confirm that an order denying sovereign immunity is immediately appealable, even absent the express statement required in the workers' compensation immunity context. So first, to begin with the text, the rule itself does not contain an express statement requirement. And this court interpreted the rule on the same day that it was promulgated in Beach Community Bank, where the court looked not to the trial court's order for an express statement, but expressly pointed to the First District's conclusion that the issue rested on a pure question of law.
I'm sorry to interrupt you. So what should we make of the fact that the court in Beach Community Bank didn't even cite the text of the rule?
Well, I think the court was well aware of the text of the rule, given that it was promulgated on the same day that Beach Community Bank was issued. And so I think that the court concluded rightly that the issue fell squarely within the new rules ambit. And the court in Beach Community Bank expressly reached the jurisdictional question because the court had called for the parties to brief whether it should quash the First District's writ of certiorari after Rodriguez, and the court only partially quashed the First District's decision because it concluded that it fell within the bounds of the new rule.
But the court kind of did that on its own. I mean, there was no opportunity for the parties to discuss the text of the rule and the cases interpreting the similar language and all that. I mean, for better or worse, the court kind of said, we adopted this brand new rule today and we're going to apply it, and there was no opportunity to kind of vet the issues that have been presented now.
I think that's fair to say, Your Honor, but I do think that the court pointed to the First District's conclusion that the issue rested on a pure question of law for good reason. I think there are very good reasons for concluding that a denial of sovereign immunity is wholly different in character than a denial of workers' compensation immunity. And so in the workers' compensation immunity context, a denial can be of two characters. It can be a ruling that there's a genuine dispute of fact, in which case the movement may present that defense to the jury and thus is not prejudiced, or the trial court can determine that the party is not allowed to present that defense to the jury. Whereas a denial of sovereign immunity is wholly different in character because whichever character it is, it denies the party entitled to sovereign immunity of the critical benefit of not having to go to trial in the first place. And so I think with good reason, the court in Beach Community Bank decided that whether or not there was an express statement by the trial court, the denial of sovereign immunity should be immediately appealable.
Although the court didn't explicitly even address the express statement issue.
That's correct, Your Honor, but it did address the jurisdictional question, to be sure. And I think that there are strong reasons for treating sovereign immunity differently from workers' compensation immunity. To begin with, it's an immunity from suit rather than a defense to liability. And this court has repeatedly explained that sovereign immunity determinations should be decided as early in the litigation as possible. And
Assume that I agree with you as to all the arguments you're making for why the rule should be different for sovereign immunity than workers' comp. Isn't that an argument for changing the rule rather than reading it differently than the exact same language in the workers' compensation rule?
potentially, Your Honor, and that is certainly something that the court could call for, but I do think that since the court has already interpreted the rule in Beach Community Bank, I think it would be consistent with Beach Community Bank to apply that different interpretation here. And a determination in this context is different than a determination in the workers' compensation immunity context. When you have a judicial interpretation of the rule, I think that overrides the usual presumption that rules should be read together. And in the sovereign immunity context, not allowing interlocutory orders to be appealed wastes the party's resources, it wastes the court's resources, it requires sovereignly immune defendants to be to go to trial, and that wastes everybody's time and money, and can subject the executive decision makers to the distractions of trial and discovery. So for all those reasons, the court has repeatedly explained that these decisions should be immediately appealable and resolved as early as possible in the litigation.
If we were to do anything in this case based on the rationale that sovereign immunity is immunity from suit rather than liability, would we need to recede from the Roe case to say that?
I don't think so, Your Honor. I think that in more recent cases, the court has explained that sovereign immunity is indeed an immunity from suit. For example, in Wallace versus Dean, the court explained that immunity from suit is derives from the separation of powers and is structural in nature. And I think that even goes back to commercial carrier, where the court distinguished between the absence of duty and the immunity from suit that is derived from sovereign immunity.
How do you square that with the cases where we said that in the petition for certiorari context that there was an irreparable harm?
So I think it's a different question, Your Honor, because while the court has concluded that it's not irreparable harm for a governmental entity to be subject to continuing suit even though it's entitled to sovereign immunity, the question in this context is different. It's not whether it's irreparable harm, but it's whether the strong policy considerations should, with those considerations in mind, the court should allow those orders to be immediately appealable.
Didn't the conclusion that there was an irreparable harm depend on first viewing the immunity as an immunity just from liability? I mean, otherwise it would be irreparable harm, right?
Potentially, Your Honor, and I think that if Your Honor wanted to reconsider that those decisions, that there wouldn't be irreparable harm, but I don't think that the court would have to conclude necessarily that it would be irreparable harm and it would be immunity from suit, because even if it were an immunity from liability only, I think that the same considerations apply, and there are good reasons for these types of orders to be immediately appealable, including the inequity of, for example, two trial courts confronted with the same motion based on sovereign immunity, and one of them including the magic words in its order, and the other simply exercising its discretion not to do so. One of those defendants would be able to appeal, and the other would not. And that's the type of inequity that I think is occurring, and that allows trial courts rather than appellate courts to determine appellate jurisdiction. And it also allows trial courts to insulate their rulings from appellate review, oftentimes by refusing to include the express statement in their orders denying sovereign immunity. I think it would also elevate form over substance to require the express statement rule in this context. And I'd also like to address whether it would be different if this were a motion to dismiss case rather than a motion for summary judgment case. The text of the rule does not distinguish between a motion to dismiss and a motion for summary judgment denial, and this court has never treated, in the context of Rule 9.130, the denials as different character in a motion to dismiss or a motion for summary judgment. And I think that's with good reason, because either way, the question presents a pure question of law. In the motion to dismiss context, it's whether the plaintiff's alleged facts, on those facts taken as true, the defendant is entitled to sovereign immunity. And in the motion for summary judgment context, it's the same question of law applied to a different set of facts, and that is the undisputed facts.
Although in this case, and you guys say repeatedly throughout your brief, you characterize it as an issue of, there are undisputed facts, and then therefore we can make an inference about what the court decided. But I mean, in this case, right or wrong, the court explicitly said that summary judgment was being denied because of the existence of disputed facts. And I know it said, including, and she gave a couple of examples that, on their face may be related more to the duty question. But I mean, at the end of the day, the order explicitly said disputed facts exist. And so this isn't a situation where you just have a purely unelaborated denial and then we can kind of look and see what were the arguments in front of the court and what should we make of that. I mean, so in this case, you're asking us to say that even though the order explicitly said there are disputed facts, you're telling us that we should construe that as an order determining that on the basis of undisputed facts, they're not entitled to sovereign immunity. So how are we supposed to square those two things?
Well, I think a couple of responses, Your Honor. First, I think that this case would be different if the trial court had expressly concluded that there was genuine disputes of fact that were germane to the sovereign immunity question, and that's not what the court did here. And that might present a more difficult case, but that's not what we have here. And I think the second response is that the district court can look at the record and the parties' arguments and determine whether the trial court correctly concluded that any dispute of fact actually went to sovereign immunity. And now that is a pure question of law, taking the undisputed facts and lining them up with the elements of sovereign immunity. And so I think that even though the trial court here said, well, there might be some disputes of fact, I think that the district court could rightly look at the record and say, well, any disputes of fact are not germane to the sovereign immunity question. And that's a pure question of law for the court to determine. So other types of immunities, such as that included in 768.28 and qualified immunity, for example, those types of denials of immunity might also benefit from, this court probably should not extend the express statement requirement in those contexts either, although the court need not address that question to resolve this case. But just as in this context, the court has never extended the express statement requirement to those contexts.
In Justice Wells's concurring opinion, I think in the Reeves case, didn't he make the exact same critique of the express statement rule in the context of workers' comp immunity that you're making now?
I think it's slightly different. I mean, I think that in the workers' compensation immunity context, it makes sense because the party asserting workers' compensation immunity is not prejudiced if it has to go to trial because there's a dispute of fact as to its entitlement to immunity. And so that's why the court requires an express statement which would preclude that party from presenting its defense.
But textually, the criticisms are the same, right? I mean, when you say that, the court has essentially inserted the word expressly into the text of the rule, I mean, that criticism is equally applicable in the workers' comp context, right?
I think that's right, Your Honor. And I think that the court could plausibly reach the conclusion that the workers' comp cases were not a fair textual reading of the rule. And for example, there are other appellate rules that do include the word expressly, such as in 9.030A2 regarding this court's jurisdiction, which provides that for jurisdiction where a district court has expressly construed, has expressly affected, has expressly certified, that sort of thing. So I think that the court knows how to use the word expressly when it wants to, and it didn't in this context.
So I understand that you guys have, you had the question that was certified in the particular way that it was phrased by the First DCA, and so, it sort of mixes the merits question with the appealability question, and essentially says, if you were entitled to, if you should have won, then you can appeal, but so it doesn't really peg it to the nature of the question. So if you weren't constrained in any way by the way the First DCA phrased the question, What do you think would be, I mean, is that the way that you would have phrased it, or do you think that there's a better way that focuses instead on what's presented to the court?
Not necessarily, Your Honor. I think that the court can disentangle the merits from the jurisdictional question. And the jurisdictional question that I think that the court should interpret the rule to be is that the district court should determine from the record whether there is a genuine dispute of fact that is germane to sovereign immunity. If there are no genuine disputes of fact that are germane to sovereign immunity, then the district court has jurisdiction. But that doesn't necessarily mean that the defendant is entitled to sovereign immunity on those facts. That's the legal question that the district court would then be addressing once it determined it had jurisdiction. So for those reasons, I think that the court should remand to the first district for the first district to determine in the first instance whether, based on the record, there are genuine disputes of fact that are germane to sovereign immunity.
The way that you laid that out, that seems to me to be a really odd jurisdictional question. I mean, you know, we're usually looking at, at this court, is there a conflict on the face of the opinion? I mean, things that are easily decided as a matter of law without looking at the record. You seem to be suggesting that we need to decide part of the appeal in order to determine whether we have jurisdiction. Well, how do we have jurisdiction to decide part of the appeal in order? I mean, it is an odd.
Well, I think they're distinct questions because, for example, in the motion to dismiss context, if a party moved to dismiss based solely on sovereign immunity and the court denied that, the court could look at a district court could look at that and say, well, that presents a pure question of law because based on those alleged facts, is the movement entitled to sovereign immunity?
It's even more problematic than that, though, that Justice Lawson said, and he's exactly right. What is the record? Talk about 9.130 structurally. How does it come to the court?
I'm sorry?
Talk to me about 9.130 structurally. How does a case come to the court?
The movement denied sovereign immunity files a notice to appeal.
Right. And what's attached to the notice of appeal?
The order.
At that point, does the appellate court have anything else?
No, Your Honor.
How's the appellate court to decide these difficult factual issues? So going back to the hypothetical that Justice Muniz gave you, how does the appellate court know not only to look through the order, assuming the order even says that there is a genuine issue of material fact, but to go back to the summary judgment record and then make that determination of whether that's there or not?
Sure. Well, that can be addressed in the briefs presented to the court.
But a court's not going to just rely on briefs for these complicated jurisdictional issues. You want to look elsewhere, wouldn't you?
Yes, Your Honor, and
okay.
I think that the court...
So how do you go about doing that? Talk to me next. What happens in the next step for 9.130? The appeal would progress as a normal appeal would progress. That's not true. 9.130, the normal appeal would be the clerk puts together the record, you have some certain number of days. Does that happen in 9.130?
No, Your Honor.
Who puts together the record?
The parties.
And when does that happen? That happens after, right?
That's right, Your Honor.
Right. So what if the party doesn't give you a transcript to know what the trial court's rationale was, which is often the case? What if there's no court reporter that was present for a motion to dismiss hearing or a summary judgment?
Well, I think that the court could then call for those materials if it required additional materials to decide the jurisdictional question.
What's the whole point of 9.130? Is it to go through this extensive inquiry, or is it to have a quick and an expedited decision-making because it's an interlocutory matter?
I think that's correct, Your Honor.
Right.
It's the latter.
So isn't what you're asking us to do completely contrary to both the text and the structure of 9.130 as related to any other appeal?
I think that the considerations presented in the sovereign immunity context call for that sort of differential treatment.
So you're saying we should not only interpret the rule as you suggest, but also take it outside and treat it completely differently than every other interlocutory appeal?
Not necessarily, Your Honor. I think that the court, if it required additional materials from the trial court, it could call for it in those circumstances.
Well, let me ask you this. What you're asking us to do in terms of this searching jurisdiction that Justice Lawson just asked you about, is any other appeal that you know of where we do the same, where we, meaning the DCAs or the appellate courts, would do the exact same thing?
Not that I'm aware of, Your Honor.
Okay. Thank you.
But I do think that there are powerful reasons for doing so in this context. And as I've explained, that includes trial courts insulating their rulings on sovereign immunity from appellate review, and that runs counter to this court's goal in promulgating Rule 9.130, which is to promote the efficiency of resolving the sovereign immunity question and to prevent sovereignly immune defendants from having to go to trial, thereby depriving them of the benefit altogether.
Yeah, counsel, you're into your rebuttal.
Thank you, Your Honor.
May it please the court. Good morning. My name is Julie Fine, and along with co-counsel Jack Fine, we represent the respondent, Lashonta Jackson, on behalf of Vontavia Robinson. We are asking this court to answer the certified question in the negative, affirm the First DCA's dismissal, and remand to the trial court. Appellate jurisdiction to review non-final orders is limited to those orders specifically listed in Rule 9.130A3, and Rule 9.130A3C11 provides appellate review of a trial court's non-final order if it determines as a matter of law that a party is not entitled to sovereign immunity. Here, the trial court made no such determination. She denied petitioner's motion for summary judgment based on disputed issues of material fact, numerous. She did cite one in particular, but there were numerous disputed issues of material fact, which prevented her from making a determination as a matter of law regarding...
Why doesn't the Beach Community Bank case govern this?
Beach Community Bank did not decide a jurisdictional issue. The court never discussed or mentioned the trial court order, so I believe the jurisdictional issue that's in front of this court today is not the same as it was in Beach. In Beach, it was the First DCA took the case on a writ of cert and decided the sovereign immunity issue within that context, and then this court took Beach to review the findings from there. It did explain that they had been asking, this court had asked at that time for a narrow rule. And
what about the language in the opinion that said the amendment to Rule 9.130 covers this non-final order, denying it sovereign immunity?
I think that that's a little bit taken out of context when we're applying it to this situation, because what this court was concerned with in Beach was whether or not there were any disputed issues, or was this a question of law? And they were saying, this court was saying in Beach, this is just purely a question of law. So this is the type of order that, well, not the order, but this is the type of case that we should be taking.
Well, let me ask you, counsel, if you read the face of the opinion, the four corners of the opinion from our court, would you know that it was an unelaborated order?
No.
What about the First DCA's opinion? Would you know that it was an unelaborated order?
No.
How could you possibly know that it's the issue here, whether it's an unelaborated order?
I think you would have to search the docket of the trial court. And
do we do that in reviewing our precedent? Do we do that in any other context where we dig through the record to determine what the opinion meant or did not meant regarding jurisdiction?
Absolutely not, Your Honor. And I believe that you and your opinion did specifically state, once an appeal has been decided and the court does not mention its jurisdiction, we cannot use that silence as precedent for the unmentioned jurisdictional issue in another appeal. And I think that's...
Well, I know I'm right. I'm not sure that's precedent for anyone else here, but that's I think the point that I'm trying to raise with my questions, which is how could we possibly use that as precedent for jurisdiction when that very fact went silent in the opinion?
Well, this isn't like a case where the court just assumes jurisdiction. I mean, in this case, the court explicitly said the brand new rule that we just adopted covers this. And what was not discussed and what maybe was assumed was that this clear statement rule didn't apply. But, you know, when the court explicitly invokes the rule and says this applies and then takes the appeal, how is that comparable to cases where the court just assumes jurisdiction with no discussion of the issue whatsoever?
I think that there is some confusion. I think that's why there has been confusion among the district courts about what Beach meant and what the purpose of Beach was. And I think that it seems from my review of all of the cases where there's a new rule, this court has added a new rule, if it's simultaneous with a decision, sometimes the district courts want to interpret the policy considerations within that case for reasons to extend the rule to their situation, to a different type of immunity. And I think this court has consistently held that that's not appropriate. But I think that in Beach specifically, the jurisdiction, how it got to this court was not through a unelaborated. It's unknown that it was brought here through an unelaborated order, and because it wasn't discussed, I don't believe that it's appropriate to use that as a basis to say that they held that this is the type of order that should be brought in front of a district court. And
Would you ask us to recede from Beach?
No, I don't think it's in conflict with this court or with the new rule. I think that it was related to
Have no application whatsoever.
no application.
Yeah, the Beach is just, has no application in this case whatsoever. No language in here, has nothing to do with the rule, has nothing to do with the appeal of a non-final order.
I think that the policy considerations that this court had been discussing and trying to have a new rule or adopting a new rule, those considerations are addressed by this court in Beach, and they are fair, and I believe that Beach, all of that discussion is good law. There's no discussion about the order itself, though, and what it requires. And so when we're trying to...
Wouldn't that be because Beach at least implies that it doesn't matter what the order says? I mean, so the court concludes that because of what came before, we conclude that we have jurisdiction, essentially. That sentence is immediately preceded by the sentence that the District Court of Appeal determined that this was solely a question of law. So the analysis in Beach is exactly what opposing counsel suggested we should be doing. They said the District Court of Appeal properly determined that this was purely an issue of law. Because of that, we have jurisdiction under the new rule. Doesn't that announce a rule that you can see from the face of the opinion that's exactly the rule that, although it seems strange to me, opposing counsel suggests we should be applying?
The rule 9.130 is the only method that this, besides a writ of cert, which 9.030, that district courts have jurisdiction to review those non-final orders. And so the rule isn't established from case law, it's established from what this court determines the jurisdiction is.
So I think if I understand, you're saying that that Beach improperly applied the rule, so that we would need to perhaps recede from it or explain the error in it in order to do something differently.
The rule wasn't in place when the trial court dismissed the motion, or denied the motion to dismiss. So to take that, to try to say that they didn't follow this procedure when a rule isn't in place, it just is applying the rule itself that wasn't in existence. And this court...
I agree it procedurally got there in the way you're saying under cert, but the opinion clearly says, at least to me, and you can argue whether you like it or not, is that they interpreted the rule to apply in this same kind of circumstances, and it accomplished exactly what, to have an interlocutory review. So I understand that you think perhaps the text of the rule doesn't do that. The majority seemed to indicate otherwise.
I think that
so it seems like it maybe maybe there's a dichotomy between what you think the court did here, but at least to me it seemed like they had adopted the language of the rule to mean that the appeal was proper. Did it not?
I think that it's worded in a way that it seems to mean that this is the type of non-final order that needs to be in front of us, but they weren't even considering the non-final order. What they had presumed, they were presuming that there was only an issue of, this was just a question of law.
So are you quarreling with the opinion itself? It seems like you are.
No, I don't have...
And that's okay, but...
I don't believe that Beach is in conflict, but I do think that it created confusion. And so I think that that's why this is in front of this court, because there are there is language within Beach which can be taken to mean a certain thing. However, I believe that 9.130 establishes the rule for one to follow, and the Beach does not establish how to interpret that rule because
It didn't interpret the rule at all.
no, I don't believe that it did interpret the rule. I believe the rule doesn't need to be interpreted. I think the rule sets out in
Because
plain
the amendment
English what it
addressed in
means.
the NRA amendments to Florida Rule of Appellate Procedure 9.130, Supreme Court 13-1493 covers this exact scenario pertaining to a non-final order denying a sovereign immunity defense as a matter of law.
And
What does that mean?
it's mentioning the rule, it's not interpreting the rule because we're not talking about the specific order.
Okay.
That's just my position, Your Honor.
It applied the rule without explaining why, right?
I don't believe that it actually applied the rule because that's not how it got to this court. I believe that this court took it upon itself to say, this is the kind of situation that we want to hear, so we're putting this rule into place.
Well, let me ask you this. How would you know what kind of order? I'm not sure that you could say it didn't apply the rule. I think that's a tough argument for you to make. But how could we know, or how could any reader know, or any district court or trial court know what kind of order was being interpreted based on the face of the four corners of the opinion?
By the language of the rule itself?
No, the order that was under review in that case. Could you possibly know?
There was no discussion of the order.
In fact, if you read it, you would think the order was one exactly like Justice Polson just read, which the order said, as a matter of law, we deny sovereign immunity, right?
Correct,
In fact,
yes.
that's exactly what the language from the First DCA was.
Correct.
You'd think the order said, as a matter of law, it should be there. In other words, it had the exact language from the rule, right?
Yes,
Right.
yes.
You wouldn't realize that the order actually just said denied.
Correct.
Right. There's no way you could possibly know that.
There's no way except for the discussion that occurred in the third DCA where this was interpreted.
So how could, if I'm a DCA trying to interpret this, for example, how could you possibly read that as precedent for when you do have an order which just says denied?
I don't think you could.
Does it guide us, assuming we were bound by exactly what Beach said, does that bind us in this case where not only do we not have an order that just says denied, but we have one that says it's done as a matter of fact?
I don't think that would be appropriate. I think that this is, you're exactly right, Your Honor. And especially in this situation where we have disputed issues of material facts specifically stated by the trial court. And I think that additionally, we have clarification about what determine as a matter of law means through this court, through cases like Hastings and Reeves, where this court specifically addresses that determine as a matter of law requires the court to come to this determination and explicitly state that they are not entitled to this defense. And so this is a case where
But was, in your view, would if this order were entered today, the one that was entered in Beach Community Bank, a simple unelaborated denial, would that be appealable under the rule in your view?
no, Your Honor.
Okay.
I believe that.
But you recognize that this court determined that it was appealable under the rule?
That Beach was appealable.
Yeah. That denial was appealable under the rule.
I recognize that the way that Beach got to this court was through cert. I don't know what this court considered. I wasn't back there. I wasn't determining it, but it doesn't say it in its order that it looked up the order.
Because this case falls squarely within the new rule amendment, we determined that the city should be entitled to the benefit of the new rule. I mean, before the rule, it clearly wasn't appealable, but they're saying that this is appealable under the new rule, so we're going to go ahead and hear the case. Isn't that what Beach says?
I think that this court took the determination that there was only a question of law and said, because there's only a question of law, which is what we are requiring, we are
Right.
taking this case. But
Right, and what they said, isn't it, is that where the district court determines that this is purely a question of law, the new rule applies, and we're going to take the case. That's what they said. In this case, the first district concluded that the city's claim to sovereign immunity rested on a pure question of law.
Yes, Your Honor.
Based on that determination, we agree, and because this case falls squarely within the new rule amendment, we determined that, I mean, that's how they said the rule worked, apparently.
But the First DCA didn't review Beach through the non-final order rule, they reviewed it through a writ of cert. So what they were considering wasn't just the order. They weren't just considering the four corners of the order. They were considering everything, and they made that determination. And once they made that determination, this court said they made that determination question of law, and that's why we believe, that's my interpretation of what happened, and obviously that can be disagreed with, but...
Well, the first DCA opinion references an interlocutory appeal, not a cert. Is that, am I misunderstanding that?
The first DCA mentions...
It came to the first as an interlocutory appeal, not cert? Did it not?
No, it was cert.
I believe they recognized it as a cert, a writ of cert.
Can you defend, though, it seems like the express statement rule kind of exalts efficiency and form over the substance of arguably what, the reason why the court has made orders denying sovereign immunity with or without the express statement rule is obviously because of the importance of the issue, the need to get it resolved early. So if you're just kind of looking at it on a blank slate, why should sort of the efficiency benefit of having the express statement rule outweigh the substance of letting courts, where the issues really are legal questions, letting the appellate courts review those?
I think that it's difficult to say that the district court should make these determinations by reviewing a record which could be very large, which in our case it is.
But the express statement rule, not as if the case law says there has to be an express statement and detailed analysis of what So if you get an order that says I'm denying it as a matter of law and there's no explanation, in a way, really all that the express statement rule does is make it easy to sort of determine on its face whether it should be appealable. But as far as the actual work that the district court has to do to see if that's correct, I mean, it's not as if that gives you a much of a head start on the analysis.
I agree with that. I think this court considers policy considerations, the policy considerations of the increased workload. It takes from the Florida Bar Rules Committee, it gets this information about what language it should use, how much this would burden the appellate courts. And I think that this court is much more knowledgeable than I am for why limited and limited non-final orders, why that should be the rule. And I think the thrust of 9.130 is to restrict the number of non-final appealable orders. So I think that increasing that is a determination that the court can make if it wants. There's language where the court has certain cases where if it grants or denies an order, in those circumstances it's automatically appealable. But in this instance, it's relying on the trial courts to make a determination as a matter of law, and I believe that's proper. And I think that with cases like workers' comp and sovereign immunity, there's always a chance that the district court says, trial court's right, go back. And then they can bring it up as an affirmative defense later. They can file another summary judgment motion. This is not going to stop them from doing those things again, which if it wasn't the way it is, then they could appeal it automatically if it's denied again. And so it's going back and back up to the appellate court, and there's not a final judgment. And that seems like a waste of judicial resources when the rights of the parties aren't being infringed.
Let me ask you a question. And I may be missing something elementary in formulating the question, but say this had arisen in a different way. Say you had moved for summary judgment on the issue of sovereign immunity, and that had been granted. What would be the status of that? So
if the plaintiff had moved to establish
that they
are sovereign.
They raise a sovereign immunity defense, and you bring a summary judgment motion seeking a determination as a matter of law that they're not entitled to their sovereign immunity defense, that they and you won on that. Now, we know that's not what happened here. But I assume that could happen in some case.
Sure.
How would that fit into the?
I believe that in that situation, if the order stated that they aren't, that they're, that the.
Well, say even the order didn't state it. Say it just stated the plaintiff's motion for summary judgment is granted.
And I think that.
Would the formality, the insufficiency of that be an impediment to that
I don't know.
going forward?
I don't know what efficiency concern, like, this court considers specifically, but I do know that this rule has, this court has interpreted 9.130 and these certain subsections which have the language determined as a matter of law to mean that there needs to be an express statement. It's creating a bright line rule that's helpful for district courts so they know when they have jurisdiction. And if the order didn't state it in that situation, then I don't believe that the district court would have the jurisdiction under that rule. Perhaps this court, perhaps they take it under cert. I'm not sure if that would be appropriate, but I think.
You've answered my question, and your time is up.
Yes, thank you.
So to your question, Your Honor, I think that in that context, it would similarly be immediately appealable because it would be a determination that the defendant is not entitled to sovereign immunity as a matter of law.
Well, counsel, can I jump in there? Why are we assuming that it just says granted in Chief Justice Kennedy's example or denied in other examples? Why are we assuming that just because the motion was only based on sovereign immunity, the response was only based on sovereign immunity, that the determination of the court was as a matter of law on sovereign immunity? What if the court is just wrong as can be? What if the court just assumed, wrongly, that they don't grant motions to dismiss, they have discretions to deny motions to dismiss and allow cases to go to discovery and summary judgment to put off making these very difficult determinations?
Well, I think that's all the more reason why these orders should be appealable, because then you have a trial court that's acting outside its discretion.
I don't disagree. We may need to change a rule to allow for these sorts of things. So I don't disagree with the premise there. But my point is, why we seem to be operating under this assumption that it's always a matter of law just because the motion frames it that way, the response frames it that way, and that's the motion. But sometimes courts just get it completely wrong. In fact, we have some examples of them getting it completely wrong. Why, given that record, would we make the assumption that it is a determination as a matter of law?
Sure, Your Honor. Well, I think it's a fair assumption that when a party asks a court to make a determination and then the court makes a determination one way or the other, that determination is based on what the party was asking for.
You don't do a lot of trial work, do you, Mr. Baum?
No, Your Honor.
All right.
But I don't think that the court should extend the express statement rule in this context. And that brings us back to Beach Community Bank, because there the court said, here's a new rule, here's how we're going to apply it. We're going to look to the first district's conclusion that there is a pure question of law, and the court didn't even consider whether there was an express statement because the court has never extended it to this context. So there would be no reason for the court to look to whether the order had an express statement.
Counsel, your time is up. If you want to sum up in about 30 seconds.
Thank you, Your Honor. For all the reasons stated, the petitioner respectfully requests that this court reverse and remand to the First District. Thank you.
Thank you. We thank you both for your arguments. And we will now move to the second and final case on today's docket, which is Jordan versus the state of Florida.